Welcome to the next in our video series of employment law during the pandemic. I'm Louise Brenlund, a Senior Associate in the employment team, and I'm joined by Lily Toppo, HR consultant from our sister company, Kent HR. Today, we're looking at grievances and dealing with grievances during the pandemic. This is something that we have seen a really large increase in for our clients, and it's something that we're being asked lots of questions around. Should you or shouldn't you be dealing with grievances, and the best way of dealing with grievances? So we thought it would be a helpful topic to address.
Louise, I understand that there is new Acas guidance on consideration during pandemic. What does this suggest?
Yeah, that's right, Lily. So Acas have updated their guidance, taking into consideration the pandemic and obviously the changes that all employers are having to take into account with regards to the pandemic and different ways of working. So as already mentioned, so employees definitely still can raise grievances and probably will be raising grievances over all sorts of issues, and quite possibly different issues to those which were being raised before. So, for example, it could be to do with online conduct and how they're being treated in a virtual world to the real world. So that needs to be taken into consideration. The ACAS code is important, just as a little reminder that if a matter does end up at tribunal, the employment tribunal can take into account the ACAS code of practice. And if that is unreasonably followed, then there can be an uplift provided in any compensation of up to 25%. So this is why it's so important that employers are aware of that and they take the code into practice, as well as these changes that have now been recommended. So the changes that have basically come into account are one around, is it actually necessary to continue with the procedure? So the suggestion is that employers as a starting point should be thinking about whether the grievance is so essential that it should continue. So, for example, again, if it is of a harassment nature, that probably is something that is so important it needs to be dealt with, and then they need to go on to look at the other considerations that I'll come on to. However, if it's a grievance that doesn't really have to be dealt with at this point in time, the recommendation from the ACAS Code of Practice is that actually, is it something that can be put on hold at the moment? And if it can be put on hold, potentially that's going to be a reasonable step to be taken. The next consideration is around health and safety. Can you comply with the public health guidelines that have been given? Are you able to do those things? So, for example, if they're coming into the office or if there's a need to come into the office, can you keep social distancing measures? Are you able to comply with all the recommendations for your business and your environment? And again, if you're not able to do that, potentially you should give a consideration to not continuing with the process at that stage. And then thirdly, if you do need to continue and you can't comply with going into the office, you can't comply with those health and safety considerations, is there another way of doing this? And the alternative way, as you can imagine, is considerations around video conferencing. However, there's then quite specific considerations that then need to be given around video conferencing and the adaptations that you need to be made to then deal with grievances in this new kind of virtual world and this new style of pandemic. You need to be very careful on each circumstances and facts, and you shouldn't be making a decision that we're just not going to deal with any grievances. It should be fact sensitive, looking at each matter, assessing those matters, and also really emphasise the need for evidence and to back up and keep evidence of your decision making around that. Again, just in case there is a claim that follows as a result of that, so that you can explain why you've made those decisions. So following on from that, Lily, what kind of things do you think employers need to be thinking about as in terms of adapting towards dealing with grievances as part of the pandemic?
So Louise, I guess if face-to-face meetings are not possible, then obviously, as you suggested, employers can either pause the process or conduct investigations or meetings remotely, such as via video. So if you are considering carrying on with the process and conducting investigations and meetings, then you should ensure that all parties involved in the process have access to technology for for video meetings. So such as, do they have the correct equipment, the software, the internet connection, and so on. Another consideration is if whether reasonable adjustments are required for those with a disability or those with the inability to use video technology. Do they need any training to use such technology? Employees still, through the process, employees still have the right to be accompanied by a colleague or a trade union official at any formal grievance hearing. So although the companion must be allowed to take part, in the hearing, they shouldn't answer any questions on the employee's behalf. Also, if the companion is unable to attend a date or a time of the hearing, then the employee should be allowed to rearrange, suggest another date for the hearing, which is usually no more than 5 working days of the original date. Also, the pandemic should not impact on the ability to carry out a fair and reasonable investigation if required. So there may be a requirement to appoint an investigating officer who should be somebody that's not previously been involved in the matter. So briefly, an investigation may involve checking policies and procedures, reviewing any relevant documentation regarding the matter, discussing the matters that the employee has raised with other employees to establish their version of events, including any external parties that you might need to speak to as well. It's important for the investigating officer to be as open-minded as possible when looking into the substance of a grievance, and they shouldn't make any assumptions or jump to any premature conclusions about the employee's motives and reasons for making the complaint or who is to blame for a particular problem.